This week's presentation will be on Chapter 5, Searches for Electronically Stored Information and Electronic Surveillance. To ensure compliance with the Fourth Amendment particular requirements, officers must specifically follow the following applications for search warrants and electronically stored information. It's a little bit different than a general search warrant. The crime for which the evidence has been sought must be specified. The reason why there's probable cause to believe that the computer or other electronic storage device contains evidence, the dates and time frame that are relevant to the investigation, and the relevant search strategy in particular, non-technical terms to ensure that a search does not become general rummaging expedition as opposed one with particularly defined parameters. So you got to specifically say what you're looking for in the computer. Are you looking for email communications involving the suspect and the victim? Or are you looking for child pornography? I mean, you just can't say I want to search the computer. You have to specify what you're looking for. Computer forensics is a very specialized type position. You have to have a lot of training in order to make sure you get it the proper information. It's real easy to hide something on a computer, and it takes a little bit of knowledge to learn how to find it and to safely store it and to preserve it in a manner that it can be utilized in court. So in order to do this, most computer forensics are going to basically make a duplicate copy or image the data. They're not going to work on your hard drive. They're going to make an exact bit-by-bit copy of that hard drive, and then they're going to examine that image. You mostly think of, when you think of computer forensics, is the actual desktop or laptop computers, and there are a lot more devices today that are going to be holding quite a bit of images or data that can be used in a criminal investigation. We'll talk about some of those shortly. Well, exactly what is digital evidence? Information and data of investigative value that are stored or transmitted by electronic devices. They can transcend borders quickly. I mean, let's face it, you can sit down here and send an email to someone in Australia and they will have it within seconds. You can upload entire videos and the movie length videos within a very short period of time, all the way across the world. Information is going to move very rapidly. Data in computer system is highly susceptible, if I can say that word, to alteration or destruction. I mean, you can change a file rather quickly, as you can send it to someone. You can erase it, copy over it. Easy to damage it. Caution must be exercised when collecting and transporting data. Oftentimes, people that are using computers illegally, and know that there's a possibility of police trying to obtain that, will have built-in systems to automatically destroy it if the information is accessed in a manner which would be would lead them to believe that the police were trying to hit it. So, they may have a self-destruct. If you don't put in a certain code, it could reformat the whole hard drive and just destroy all the evidence. Special training and skills and equipment and specific software are needed to retrieve this evidence and preserve it so that it can be used in court. It's not just getting it. You got to be able to explain how you got it so that it can be utilized in a court. There are more than one ways to get into the computer, search warrants, and again we talked a little bit about that earlier. And then you can also get consent to search, much like you can get a consent to search someone's house or consent to search a business. You can get a consent to search a computer. Some of the things you have to look at are identifying the evidence to be collected and where the evidence can be found. You have to document the collection and you have to preserve the evidence. So you got to be able to show the chain of custody and how you got the evidence. And again, when you transport things, you need to recognize all items that could contain the vital information where you're searching it, and make sure each one of those is safely transported to the proper forensic laboratory. In Texas, the Texas Department of Public Safety has a crime laboratory who will handle forensic examinations for the police departments throughout the state. Their policy is that they want a copy of the search warrant or consent to search before they do an examination. They want to make sure that everything's above board. And they say there must be specific wording in there, not only allowing them to seize the media, also to access the data stored within the media. There's a difference between seizing the computer, physical computer, and seizing the data that is held within the computer. This requirement provides protection at the time of trial, preventing the examiner of the evidence from unlawfully search of the data contained in the item submitted. This is an example how the digital evidence differs from other types of evidence that can be seen in plain sight, because you can't see the data that is on that hard drive without using other means like booting the computer up. Search warrant to collect possible evidence of a crime at the crime scene typically covers the evidence you can walk into the room and see and touch. It is more intrusive search to get into the laptop and remove the hard drive and examine and search for evidence of crime. That's why you need some specifics in there that not only do you want to search for the laptop, but you want the data contained in the laptop. The laptop may be evidence. I mean, if it's a stolen property case, you really don't need to get into the computer to find that it belongs to the victim in the case. But if you want to get in there and you're looking for child pornography, you need to specify that you want to get into the data inside the computer, not just collect the computer. The wording of the search warrant or consent should specifically state that the data which resides on the seized digital media will be forensically examined, recovered and searched by a forensic crime lab, be it DPS, Secret Service lab, or a local police department's own lab. A common misconception about the search warrant is the return to the issuing judge. You don't actually have to search the data within the time frame allowed for issuing of a search warrant. You have to, you can physically seize the computer during that period and hold it until the forensics examination is completed. There are many different types of electronic data, including the old 5 1/4-inch floppy disk. You've got computerized data on personal computers, laptops, external hard drives, including UPS drives, Wi-Fi connected terabyte drives, DVDs, CDs, floppy disk, flash drives, including thumb drives and USB drives. The micro drives are so small you could have all kinds of data that you could fit inside of a shoebox on if you have multiple of the micro USB drives. PDAs, those that exist, including iPods, tablets, cell phones, both BlackBerry, if there aren't any of them around, iPhones and Androids can contain multiple amounts of information. A few MP3 players left. Then the new things are the tablets. All can contain information. Your Xboxes, your Game Boys, whatever you call them today. I'm probably not giving you the most relevant new ones, but the Wiis, all of those have like electronic storage devices in it. Smart TVs. I've just purchased a smart TV. It will store some information in it. It doesn't have a big hard drive, but it stores information like access to Facebook pages, Netflix, and those things. And it will also can be used for movie and video displays. In the case of the one I've got, it does not have a hard drive on it, but it does allow you to to plug in a USB drive into it and use it more as a player than the storage. But it does have a limited storage capacity. Other items of evidence that you're going to find at the scene that you need to You may need to seize the computer media relevant to the crime, of course, documents about the computer. Sometimes computers aren't going to be easy to access. If there's, if it's an obscure type, you want to secure any documents that will aid the lab in getting into it. The printers, scanners, and the trash. Yeah, you need to look in the trash for things. Sometimes people store their thumb drives and such in the bottom of the trash because they think law enforcement won't look there. And before they throw out the trash, obviously they're going to pull their stuff out. And they're small. They're easy to hide. Webcams. The PDA cell phones with charger and the data cables, and this can be important because there are so many different types of computers or especially the cell phones that sometimes you don't have the right method of plugging it in. So if you have a data cable to plug into the phone that will plug into the computer, it'll make it a whole lot easier when you try to go download information. Related software, related cables, power cables, and chargers, particularly again if it's an odd type computer where it may have a different type cable or system to plug it in. There are just a multiple of things. Printers now have storage on them. Copiers have storage on them where you can store previously printed material and reprint it. So that could be valuable. Again, you have to specify in your search warrant you're looking for it, though. Typical office. Look at all the potential devices here. We've got laptops, computers. We've got different cell phones, printers that we don't even have an arrow pointing at. And then there could be multiple of storage devices in here, USB drives and the like. So you got to look for things because there's going to be. It's real easy to hide electronic storage devices today. And then the media examples, hard drives again, picture frames. You've got a storage device in that picture frame, digital picture frames obviously, that doesn't necessarily just contain the pictures that are displayed on it. You can have additional documents and information in hidden folders inside that device, and you can have multiple gigabytes of these storage devices, so you can have a whole lot of information easily secreted there. And of course the tablets, external hard drives. You just got to look around, try to figure out what might be the electronic information. Then just a look at some examples of USB drives. I find the Swiss Army knife USB drive to be really unique looking. If you're searching a guy for, you may not think to look for a storage device in his knife. Pins with a USB built right into them are kind of unique. They're easy for somebody to overlook. Again, somebody's digital player, their iPod or whatever, could have storage that have files on them that are not related to music, because it doesn't matter where you store the information, or what type of information stored on there may not be able to utilize that information on that device, but they can store it there. Look at the mini SD cards so you can see how small they are. Think about how many of those you could store in, like I say, in the space of a matchbox. And then USB devices that are made to look like keys. The one that I utilize the most of the time is a key-shaped one, and it's got I think 32 gigabyte of data on it, so it's a rather substantial device, and it doesn't look like a USB device unless you know what it is. As far as getting into a phone and looking at information, one of the big things that most police agencies use, or not most, but a lot of police agencies use, is a device called the Cellbrite. This device, which is frequently updated because phones are changing all the time, comes with multiple cables to try to hook up to the different devices. When you get into them, they will will try to bypass passwords on cell phones. They will try to get all the data out of the phone, including text messages sent and received, all digital movies and photographs, records of all phone calls. Whatever information is left in that phone, it tries to pull it out. It's not always successful in getting information out, but it is quite often. Now, due to recent court decisions, we can no longer take a cell phone from an arrestee and search it incident to a lawful arrest. You actually need to get a search warrant to search inside the phone. Of course, you can take the phone from them as property in jail, but you cannot search inside that phone without getting a warrant, without probable cause to get a warrant, and then obtaining the warrant. Electronic surveillance refers to searches conducted using wiretaps, bugs, or other devices to overhear conversations or obtain other kinds of information. In the scheme of things, they're relatively recent concept in criminal and constitutional law. Obviously, when our Constitution was written, we didn't have any electronic surveillance, so it wasn't quite addressed by our forefathers in the Constitution. The Constitution, therefore, gives little guidance on what should be allowed by law enforcement. Well, the first case that reached the Supreme Court involving electronic surveillance was in 1928 in the case of Olmstead versus the United States. There, the court held that wiretapping was not covered by the Fourth Amendment because a conversation wasn't tangible. It wasn't something you could touch. It wasn't property. This changed in 1967 with the case of Katz versus the United States, where they decided to go with it from a different approach or different perspective. Instead of looking at it as property, they looked at it as a privacy right and said that electronic surveillance does fall within the realm of the Fourth Amendment because of the right to privacy, not the right to not a property right. The Omnibus Criminal Control Act and Safe Street Act of 1968 addresses criminal electronic surveillance. Title III of the Act attempts to balance the need to use electronic surveillance for effective law enforcement against the rights of the people to be protected within their individual privacy through judicial supervision of all aspects of electronic surveillance and establishment of a warrant procedure, which is a little bit more detailed than a general warrant. It's not something that the typical patrol officer is ever going to write a wiretap warrant. Electronic communication in this act is defined as any transfer of signs, signals, writing, images, sounds, data, or intelligence of any nature transmitted in whole or in part by wire, radio, electromagnetic, photoelectronic, or photo-optical system that affect interstate or foreign commerce, but does not include A, any wire or oral communication, B, any communications made through a tone-only paging device, or C, any communication through a tracking device, or D, electronic funds transferred, information stored by a financial institution in communication system used for the electronic storage and transfer of funds. So, there are a few things that were exempted from this law back in '68, and again, this is a federal law. That's why the interstate or foreign commerce is put in there, because it is for the federal wiretap, not a state level. Oral transfer means a transfer containing the human voice at any point between and including the point of origin and the point of reception. So oral with an A. Oral communication, oral with an O, is any oral communication uttered by a person exhibiting or in expectation that such communication is not subject to interception under circumstances justifying such expectation, but such term does not include any electronic communication. So when it's with the O oral, that's your right to privacy and in conversation in your house. You don't have the same expectation to privacy if you're sitting in this classroom and talking out loud about something, and there's a police officer sitting in here. But inside your home, where there shouldn't be a police officer, to your knowledge, you do have a right to that privacy. Wire communication under this law says any oral transfer made in whole or in part through the use of facilities for the transmission of communication by the aid of wire, cable, or other connections between the point of origin and the point of reception, including the use of such connections in a switching station, furnished or operated by any person and engaged in providing or operating such facilities for the transmission of interstate or foreign communication or communication affecting interstate or foreign commerce. Such terms include electronic storage of such communications. So again, this is a federal law. That's where the reason for the interstate or foreign communications being thrown into this definition. And to intercept the oral or other acquisition of the contents of any wire, electronic, or oral communication through the use of electronic, mechanical, or other device. So the interception is where you do the wiretap itself. Title III specifically authorized state law enforcement officials to apply for, obtain, and execute orders authorizing or approving the intercept of wire, oral, or electronic communications. So these procedures are similar to the previous law we were talking about governing federal interceptions. The state procedure must be authorized by a separate state statute, and we do have such a statute here in Texas. In Texas, the wiretap, they're infrequently used at a state level. There are more federal wiretaps going on in this state than there are state wiretaps. In fact, in 2007, there were only 4 wiretaps authorized in Texas under the state law, and those were all in Harris County, so right up the road here. And they all involved narcotics cases. On the federal level, there are, again, I said a lot more. Every wiretap I've been involved in or known about has involved federal narcotics cases, and involved usually the DEA or the FBI actually running the wiretap. By comparison to Texas, Los Angeles County alone had 291 of the 660 wiretaps ordered in California in 2007. So they use a lot more wiretaps at the state level in California than we do here in Texas. Arizona, a much smaller state than Texas, that same year had 35. And then Tennessee, again, even smaller, they had 19 orders. So we don't utilize them as much at the state level here in Texas. Would be because of the difficulty of obtaining them and the fact that DPS has to be involved in all of them. Each of Texas' 9 judicial regions has a district court that is authorized to sign intercept orders, and they are limited to very specific cases. It's either got to be murder or capital murder, child pornography, or a felony drug offense other than possession of marijuana. And again, the only ones in Texas in 2007 did involve narcotics cases. Texas Department of Public Safety is the only agency in Texas authorized to possess, install, or operate the wiretap equipment pursuant to state law. Of course, at the federal level, they have other agencies that do it. The DPS technical unit is located at the main headquarters in Austin. Actually has 4 monitoring rooms for the wiretaps. Each room can monitor 2 phones each, so they can only do 8 at a time with the equipment they have. And again, it's all done in Austin. You don't have to be in the area where it occurs because it's all done through electronic wiring. Under Texas law, the application for the wiretap must be made by the elected district attorney, criminal district attorney, or a county attorney with felony jurisdiction at the request of the head of a law enforcement agency. So again, we're making this very difficult to get. You got to jump through some hoops. You got to get to your chief of police to ask the elected DA to put his neck out to obtain the warrant. Before the application is sought, the director of the FBI must approve the project in writing. So that's even further and more hoops to jump through. That's the reason we only had so few of those wiretaps at the state level. The affidavit must demonstrate that probable cause for one of the enumerated offenses exists and that the proposed wiretap will likely intercept relevant communications. When possible, it's necessary to identify the target of the wiretap and the location of the relevant telephone, which is not as easy today because most people are going to be using cell phones and not hardwired phones. Finally, the reviewing judge must be satisfied that traditional investigative methods have been tried and failed or would be too dangerous or impractical. And there's no fishing expeditions, so you generally go, well, I've got information, John Doe's selling drugs, let me wiretap his phone to see if I can get some information to help prove it up. When law enforcement officials intercept communication that relate to an offense other than those specified in the interception order, the government may use the evidence of those other crimes only if another application is made to a court as soon as practicable for determination that the intercept complied with the Title III requirements. So you can use the information, but you do have to get the court's permission to use the other information other than the case that you were actually working on before it's legally entered into court. Title III is a broader in both scope and remedies for the remedies for illegal use of wiretaps than the Fourth Amendment. And notably, Title III applies to private searches and seizures of wire, oral, and electronic communications, not just those involving government. So the exclusionary rule federally only excludes illegal evidence that was obtained by law enforcement personnel. In this case, it excludes civilian personnel also. Texas, our exclusionary rule excludes civilian also, so it doesn't really matter at the Texas level. When it mandates or violated, Title III provides for its own statutory remedies. Title III provides both criminal and civil penalties for violation of the commands aimed at protecting privacy. For example, in the case of United States versus Councilman, 2005 case upheld that criminal charges against an internet provider for illegal interception and copying of email messages. A similar case from 2008, DirecTV Inc. versus Roland, ordered damages for a satellite TV provider against a customer who used illegal devices to access programming beyond the terms of his subscription. So, it's not just used as a tool against law enforcement who are illegally wiretapping people. In this case, Rollins was, probably a subscriber to DirecTV, but he was getting premium channels that he wasn't paying for, and there were charges brought against him for violating this act. Title III also contains its own statutory exclusionary rule for the intercepts that were illegally obtained by either government or private persons. The reach of this exclusionary rule is much broader than the judicially created exclusionary rule of the Fourth Amendment violations. Again, in Texas, ours is pretty similar to what's in Title III, not with the federal Fourth Amendment has been a little bit more stringent than it is elsewhere. You must have standing to object, but any aggrieved person may move to suppress the contents of or evidence derived from an oral or wire intercept that were obtained in violation of Title III in either state or federal proceedings. And again, it's not just the wiretap information itself, it is evidence that was obtained as a result of that wiretap. So if you hear them talking about where they've hidden the stolen property on a wiretap that's illegally obtained, you can't use the fact that they said anything about where the stuff was. Or if you go to that location and recover it, you can't use that bit of evidence because you illegally have found it. An aggrieved person means a person who was party to any intercepted wire communication or a person against whom the intercept was directed. So to be if you've got two people that are talking about their friend that had evidence hidden in his illegal wiretap, they're not the aggrieved party because they're not the ones that were talking on the wiretap, or the person who was the wiretap was against. Like you've got a wiretap against John Smith's phone, and John Doe and Jane Doe are talking about where Joe Blow hid something. Joe Blow's not an aggrieved party. He can't claim this, that it was a violation of his rights, because he wasn't one of the three parties that were involved, the two people that were on the phone and the owner of the phone. Types of electronic communication that are not covered under Title III, including cases of willful and voluntary disclosure. So you have a right to record your own phone calls. Certain cases of eavesdropping. Again, you're sitting in a public place and someone's talking loud enough for you to hear about what they're planning on doing. That doesn't fall. Consent surveillances. People will often have the police watch their houses, because they think somebody's going to commit a crime. That doesn't. Providers are allowed to obtain certain information because of their rights as a provider. Computer trespasser exception says that if you break into my computer and you don't have a right to privacy where you've hacked into the computer. If I search the computer that was hacked into, too bad, you shouldn't have hacked into it. We can use it. Public access exception. The PIN registers, trap devices, and trapping devices are also exempted. And a PIN register is an older system where they actually registered the phone calls you called. It's a lot less intrusive than recording the conversations. It just tells you that this phone called this number at this time. Then emails, voicemails, and video surveillances are also not found under Title III. Well, that concludes this week's presentation. Next week we're going to be looking at Chapter 6, Administrative and Special Needs Searches.